Hello, everybody. My name is Claudia Bortolani. I am the managing partner of Aliant in Italy, in Rome, and I'm here today to speak about the consequences on the contractual obligations caused by breaches due somehow to the coronavirus, this emergency, health emergency that has touched Italy very much profoundly and that is hitting most or many of the countries around the globe. After almost a month from the burst of the epidemic in Italy and the even increasing restrictive measures that our government has and is still taking, actually, one is expected for tonight, the day I'm speaking, which is March 24th, to contain the epidemic. All people who have pending contracts are called to face the question of the possible or actual non-fulfillment by themselves as debtors or by their counterparties. First of all, a difference must be made between cases where the debtor can no longer fulfill its obligation from those in which performance is still possible, but simply made more burdensome by the current emergency that we're facing. The first case would be what in international agreements is called an event of force majeure, simply impossibility to fulfill the obligation. The other and different case is, as we were saying, the case in which it is still possible performance, but it is just much more onerous for the debtor to fulfill. And the second case is probably similar to the international concept of hardship. But let's go back to the first case, the case which is generally defined as force majeure. As you can see from the slides, the first slide, in the Italian legal system, there is no definition of force majeure. There is not a provision, we have a system, a legal system of civil law as opposed to common law. And so everything for us is written in the statutes. But we do not have a specific definition of force majeure. There's no such an article that titles force majeure. It is referenced here and there, but the article in the Civil Code, which we are going to take as a reference to define this situation, is Article 1256, which titles liability of the debtor. According to this article, I'm just, reading and basically doing a almost literal translation. According to Article 1256 of the Italian Civil Code, which governs performance of the obligations, the debtor who does not duly fulfill the agreed upon obligation is called to reimburse the other party for all damages the other party suffered, unless, there's an unless, the debtor proves that the non-fulfillment or the delay was determined by the impossibility to perform the obligation, determined by a cause not attributable to him. What does this article mean? The impossibility, according to our case law, must be, first of all, objective, and second of all, absolute. But let's give some examples. For example, payment of a sum of money by our courts has never been considered as impossible. This appears also to be in line with some US decisions that, for example, did not excuse the debtor from payment of a sum of money, not even after the crash of the financial system in the 30s. So for the payment of the sum of money, it is hard to say that it has become impossible, because you can always find money. It's something that, you know, it has not been affected by an absolute and objective impossibility to find money. But again, let's give some more samples. Another court, we've been examining case law, and I've tried to get some case law to give you an idea of what this concept, which is the concept more similar to force majeure, means in our country. I was saying another example is a court that did not recognize as a force majeure event a case in which the occupation of a factory by the workers, and thus the total freezing of the sales, prevented the debtor from paying a bill. Also, the obligation to supply and deliver goods determining their kind, but not unique. Let's think about, stuff that you can find in large quantities, and there is one is the same as another. This obligation, which refers basically to commodities or goods that are not unique, is not eligible to become impossible. You can always find other goods that are the same, and so they're replaceable, unless an event occurred that struck all of the producers of those goods and thus made it impossible to find them on the market. Or again, it could be that the goods could no longer be produced by order of the authorities, and thus those goods actually disappeared from the market. These could be cases where Article 1256, which in the presence of these two circumstances, which are an event that is determines an absolute impossibility, and the second one is that the event must not be the responsibility of the debtor. These are the events where the breach by the debtor would be excused. With respect to commodities, for example, another example is a court that I was reading that held that the debtor responsible for failure to supply a quantity of sugar that had become extremely expensive due to war events, but it was still possible to find it. So we're talking here not just of the difficulties, onerous, the more onerous predicament in which the buyer is found, but of the impossibility to fulfill his obligations. In case of obligation to do something, performance has been considered impossible when it would not be possible for any individual in the same position to execute and perform that obligation. So in all cases, the debtor is the one that will have to show that the impossibility to perform was due to a cause not attributable to him. This means that the debtor will be held responsible in all cases in which the impossibility to perform was due to an event that he had a duty to avoid. So here also the concept of diligence enters into play. In summary, we could say that the debtor must have acted in a diligent manner, and also he must prove that he did all he could do to perform. Again, we're saying that a simple hardship would not do it. And a hardship, even a big one, would not free the debtor from liability for the applicability of this provision 1256. Eventually, according to another provision, which is Article 1256, An obligation terminates when, for causes not attributable to the debtor, performance becomes impossible. And then, of course, the other party that has maybe fulfilled this obligation or not yet, in one case, would have an action to get back or to get paid for what has provided. And in the other case, the other party who still has not fulfilled this obligation would be excused from fulfilling, from performing. So in this, we briefly try to explain how in Italy the concept of force majeure would work. There's another provision, which is Article 1467 of the Italian Civil Code, which governs the situation of, which say most similar to what in international contracts is defined as hardship. This provision provides that in all agreements that provide for an execution during the course of time or at a certain time, so there are agreements that are prolonged into time, if performance of one party has become excessively onerous due to 1, extraordinary, 2, unforeseeable events, such party may request that the agreement is terminated. Termination cannot be requested, according to this article, if the excessive burden was in the normal risk of range of the contract. The other party, however, who's requested the termination, may avoid such termination by offering a renegotiation of the terms of the agreement at fair conditions. So in other words, this differs from force majeure, this concept of hardship, because the party which is under hardship can ask the judge, and it's not something that it could do by himself, but can ask the judge, proving that certain conditions occurred, that he is excused and terminates the agreement. In this respect, case law has held that hardship must be represented by objective criteria caused by extraordinary and unforeseeable events that were such at the time of execution of the agreement. Extraordinary are all those events that by their nature, their frequency of occurrence, size, intensity, statistics, while unforeseeable, on the other hand, is determined in relation to the possible knowledge of the parties at the time of the agreement that that event would have possibly occurred. But let's give an example. Some courts have held that a severe monetary depreciation may represent hardship if it can be qualified as a risk that was unforeseeable, as not in the normal risk of range of that specific agreement. But let's try to understand better with an example tied to the current coronavirus situation. Let's create a situation where Mario Rossi, an Italian producer of furniture, entered into a contract for the sale of his products with a US distributor, who in turn had entered into several contracts with his clients in the US. Let's assume that the Italian producer ordered the wood from a French seller whose production was stopped due to urgent provisions issued by the French government. What would happen in this case? Of course, the US distributor would be responsible vis-a-vis his clients, and he would try to be held harmless from the Italian producer, who in turn would seek damages from the French wood seller, who would justify his breach by a force majeure event. Who will be ultimately responsible, and who would have to bear the risk of damages, of suffering damages? In this case, let's also assume that the agreement between the US distributor and the Italian producer was subject to Italian law. First of all, an Italian judge would review the agreement of the litigating party and verify if a clause of force majeure and a clause of hardship were present and what they provided. Even in our country, where agreements tend to be less detailed, not as voluminous than in the other countries, as we are a civil law country, and the civil law and civil code regulates in details all our contract matter, the international practice based on the common law models, even in our country, has determined that such clauses are always present. Also, although so far they were considered a sort of Cinderella of the agreements, these clauses of force majeure. Once you are, down to the agreement and you are towards the end, you see all those boilerplate provisions, and force majeure for years has been considered one of those, as I was saying, Cinderella provisions. Well, usually in Italy, such clauses do not contemplate epidemic or pandemic provisions, but often, though, they state that force majeure events, including but not limited to, meaning that the list of events is not limited in number. So in our case, epidemic or pandemic is, if in our case this event was not contemplated by the clause of force majeure of hardship, the creditor will have to show his right to performance of the obligation by the Italian producer. It will be the producer, in order to be exempt from liability for force majeure, that will have to prove, one, that performance has become impossible. Well, in the case we were making, that the Italian producer cannot buy the timber anywhere else, which is kind of hard to prove. And number two, that the cause that rendered performance impossible is the health emergency. Well, this is not so hard to prove. Probably easier in this case is to prove hardship due to the extraordinary and unforeseeable event, and demand the judge of the contract, the termination of the contract, unless the other party, in this case, offers an equitable renegotiation of the terms. Also, a relevant impact on the evaluation of responsibility of the Italian producer will have his conduct. Did he immediately inform the US distributor? Did he try to locate a different seller? Did he adopt measures to reduce the damages? As such, the evaluation of the liabilities of the debtor is something that has to be done on a case-by-case basis. Well, lastly, in this complex matter where you see we have, more than one provision that comes into play, and a very tough burden of proof for the debtor, there's been a mitigating provision that was contained a few days ago in an urgent decree of the Italian government dated March 17th, and which is Article 91. According to this article, compliance with the restrictions introduced to slow down the expansion of the epidemic must be kept into account for the determination of the liability of the debtor, also in relation to the application of penalties for delayed performance or failure to perform. Well, again, this is a recommendation to the parties to keep into the account the current emergency situation. Who knows, and probably they probably will, what will happen with the litigation that I'm sure will come up once this emergency will be over. Well, thank you for listening, and let's all hope that we'll be successful in overcoming this health crisis. Thank you.